The chair now recognizes the gentleman from Wisconsin, Mr. Senator Sensenbrenner, for 5 minutes.
Thank you very much, Mr. Chairman. To begin, Director Mueller, let me commend you for your 12 years of very dedicated service in an agency that obviously had to change its targeting and its mission as a result of 9/11. And you and I got our jobs as leaders, me as chairman, about the same time. You're about ready to retire. I was retired as chairman in 2007, but I'm not about ready to retire from Congress or asking questions. So I'll begin. Let me start out with two quotes from then Senator Barack Obama. First is, President Bush has put forward a false choice between the liberties we cherish and the security we provide. I will provide our intelligence and law enforcement agencies with the tools they need to track and take out the terrorists without undermining our Constitution and our freedom. The second quote, which comes from the same speech in Washington of August 1st, 2007, the Bush administration acts like violating civil liberties is the way to enhance our security. It is not. There are no shortcuts to protecting America, unquote. Now, Director Mueller, you have served both under President Bush and through the transition to President Obama. What new privacy protections did the FBI implement under President Obama, and were those in place when the FBI applied for the FISA application that was leaked to The Guardian?
Well, we have internally a privacy officer. The Department of Justice has a privacy officer. I do not know specifically, but in programs such as this or other areas where we initiate collection of information, it goes through our privacy shops.
That's not my question, with all due respect. Were there new privacy protections that were implemented by the new President, Barack Obama, after January 20th, 2009, when he took office?
Are you asking were there?
Yes.
I'm not certain of the timing of whatever additional privacy protections were instituted, if there were.
Okay, so there might not have been. Well, I'm very interested in your comment about the Al-Mittar case, which was somebody who got on the radar screen before 9/11 and before the Patriot Act. Section 215 of the Patriot Act, which I had a hand in drafting, requires that the business records FISA warrants or orders be directed solely at foreigners who are the targets of an authorized terrorism investigation, and not on United States citizens unless they're contacted or involved with foreigners. Now, I don't think that Section 215 would have put a crimp on identifying Al-Mittar if that was in place before September 11th. But my question is, with respect to the FISA order that was leaked to The Guardian, is with the narrowness that Section 215 is, and as I have described it, how can Section 215 be utilized to scoop up the phone records of American citizens who are not in communication with a foreigner who is an object of an authorized terrorism investigation?
To a certain extent, I have to defer to the Justice Department on the legal theory and the FISA court. I can tell you generally that there is the belief that the body of telephone toll data has in that information that is relevant, may be relevant in the future, has been relevant in the past, and that its collection in this matter thereby satisfies the requirement for relevance according to the court.
Well, the question of relevance is the same type of question that could be issued either with a grand jury subpoena or with a national security letter without involving the Patriot Act. I hear you involve the Patriot Act in something that is done in secret, and there are no due process protections in place because the recipient of the FISA warrant can't tell what records he's turned over, and that's not the case with either national security letters or grand jury subpoenas. Now, I guess what my concern is that there really isn't any way for anybody whose records are turned over to approach the FISA court or any other court because they don't know about it to try to get the order quashed. And an FBI agent was the one that signed the affidavit to get that order. And my time is up.
Let me, if I may just follow up with one observation, and that is, as we all know, these particular records are not covered by the Fourth Amendment. The Supreme Court has held that to be the case. And secondly, the determination as to the legality and that standard has been addressed by the FISA court in the affirmative to support this particular program.